Welcome to The Explainer. Today, we're diving into a genuinely fascinating and honestly deeply human legal dilemma. We're going to look at what actually happens when the strict, unyielding procedural rules of our justice system collide head-on with someone's desperate reality. It's a story about a massive clash. On one hand, you've got a citizen looking for immediate relief because, well, they're out of time and completely out of money. And on the other hand, you have a judicial system built on a super rigid hierarchy that demands absolutely everyone follow the exact same steps. We'll be breaking down a specific 2003 judgment from the Constitutional Court of South Africa, the Phenithi case, which just perfectly illustrates this whole tension. So, here's the core question for us today. Think about how the court system usually works, right? It's basically a ladder. You start at the very bottom, and if things don't go your way, you appeal your way up, rung by rung. But what if you literally can't afford the climb? Does being completely unemployed, out of cash, and desperate suddenly act as a VIP pass? Like, can you just skip the line, bypass those lower courts entirely, and take your case straight to the highest court in the land? It's a super compelling idea. I mean, if you already know your case is going to end up at the Constitutional Court anyway, why not just start there? Save everyone the time, the stress, and the crazy legal fees. Well, as we'll see, the legal system has a very definitive answer to that. All right, Section 1, fired for being sick. To really wrap our heads around this legal battle, we first need to look at the human being right at the center of it all, Mpo Phenithi. Now, Phenithi was a permanent educator working for the Free State Provincial Government. After being out sick for about a month in May 2000, she came back to work only to find out she'd been fired. No warning, no disciplinary hearing, nothing. The government used a very specific and frankly harsh law against her. The exact wording of Section 14(1) of the Employment of Educators Act basically says that an educator who is absent for more than 14 consecutive days without permission shall, unless the employer directs otherwise, be deemed to have been discharged from service on account of misconduct. Just notice the language there, shall be deemed. It's an unyielding, totally automatic trigger. The second that 14-day clock runs out, the law essentially fires you on the spot, treating the absence as misconduct. And it was this exact section of the act that Phenithi wanted to challenge, because she believed this kind of automatic dismissal was completely unconstitutional. Which brings us to Section 2, skipping the legal line. When the standard dispute resolution process totally failed her, Phenithi decided to make a really bold and honestly very risky legal move. But looking at the timeline of events, we immediately see a massive, critical flaw in her case. Okay, so she was officially discharged back in May 2000. By February 2002, an arbitrator told her, hey, I have absolutely no jurisdiction to rule on a constitutional issue like this, and suggested she take it up with the High Court. But then, there is just this huge gap. It took a year and a half, literally 18 full months, after that arbitration award, for her to lodge her application for direct access to the Constitutional Court. For 18 months, absolutely nothing happened. And when she finally did file it, she aimed straight for the top, completely bypassing all the lower courts. This chronological drag, this massive, unexplained gap in time, yeah, that was going to become a huge stumbling block for her. Now, Phenithe's argument actually makes a ton of pragmatic sense. On one side, we have her stark reality. She was fired, she was unemployed, and she was completely broke. She argued it would cause her massive financial prejudice if she had to pay for two separate court cases. Starting down at the High Court and then inevitably having to appeal all the way up to the Constitutional Court anyway. Plus, she really wanted to avoid the endless delays of appeals and cross-appeals. It's a completely relatable, deeply human argument. But on the flip side, we have the incredibly rigid expectations of the judicial system. The court demands that you follow standard procedure. You don't just get to skip the lower courts simply because it's faster or cheaper for you, unless you can prove what they call exceptional circumstances. Moving on to Section 3, the court says no. Phenithi really hoped her extreme personal hardship would be the key to opening the doors to the highest court. But the Constitutional Court outright rejected her application. You see, to get that elusive legal VIP pass, the Constitutional Court relies on a super strict precedent from an older case known as Phenithi. Basically, just because you are challenging an act of parliament, that does not automatically justify direct access. You need to show sufficient urgency or some major public importance. And you have to actually prove that if the court doesn't hear your case right now, immediately, there's going to be prejudice to the public interest or to the ends of justice and good government. It is an unbelievably high bar to clear. So your personal financial struggles, while absolutely tragic, just don't automatically threaten the broader public interest in the eyes of this rigid legal test. The court essentially dismantled her request piece by piece. First off, they cited that totally unexplained 18-month delay we talked about earlier, which basically crushed any argument she had for urgency. They noted she bypassed the high court entirely, which is a huge no-no. They also pointed out that there might be factual disputes between her and the Department of Education, making it a terrible idea for them to act as the first and final stop. Ultimately, they ruled that just being indigent, being poor, and wanting to avoid time delays simply are not sufficient excuses to bypass proper legal channels. They brought the gavel down really hard on her attempt for direct access. So, that takes us to Section 4, Why the Rules Matter. It's super easy to look at this outcome and just feel frustrated for her, but we really need to zoom out and look at the broader systemic reasons why these strict legal hierarchies even exist in the first place. It really boils down to one core structural issue. The highest court literally cannot be the first and final stop when basic facts are disputed. Think about it like this. The high court is specifically designed to get into the weeds, to look at evidence, listen to witnesses, and establish the bedrock facts of who did exactly what and when. The constitutional court, on the other hand, is designed to look at those already established facts and decide if the law applied to them is actually constitutional. In Phenithe's case, the court realized they only had limited paperwork, and the government might completely dispute her version of events regarding her sick leave. If the constitutional court acts as the very first court, and somehow they get the basic facts wrong, well, there is no higher court for anyone to appeal to. It's the end of the line. So forcing the highest court to figure out basic, potentially disputed facts would completely undermine the safety net of the entire judicial system. The delay and the sheer cost of working your way through those lower courts are undeniably frustrating, and for someone without a paycheck, they can feel like an absolutely impossible barrier. But bypassing those courts threatens the accuracy and fairness of the final ruling for everyone. So I want to leave you with a final, slightly provocative thought to chew on as we wrap up. We've seen exactly why these rules exist, but we've also seen the real human cost of enforcing them. If justice is fundamentally too expensive and way too slow for an unemployed citizen to actually access through the standard channels, do these rigid procedural rules ultimately protect the integrity of the system, or do they effectively just punish the poor for not being able to afford the climb? It's a pretty profound tension sitting right at the heart of our legal system, and honestly, it's one that the Phenithi case leaves entirely unresolved. Thank you so much for joining me for this explainer.